The moment you see an unmarked car pull behind you with flashing lights and masked agents step out, most drivers fall into a trap. You answer their first question about where you were born, and within 30 seconds, you've given ICE everything they need to detain you. Through tactical analysis of over 200 documented ICE vehicle stops, I've identified the exact pattern agents use to turn routine encounters into immigration arrests. ICE agents increasingly use unmarked vehicles, plain clothes, and vests that say police. They stop cars based on factors the Supreme Court recently permitted, including apparent ethnicity, speaking Spanish, and location. Most drivers have no idea they're dealing with immigration agents until too late. I'm going to show you 4 tactical countermoves that shut down ICE fishing expeditions. These are exact responses grounded in Fourth Amendment protections and court settlements that restricted ICE authority. Learn these 4 lines and you control the encounter. This is tactical education only. For specific legal guidance, consult a licensed attorney. Countermove number 1 is the question that separates a consensual encounter from detention. Am I free to leave? Here's the real situation. When ICE approaches your vehicle, they create the illusion you're being detained when legally you might not be. They position at your window. They ask questions. They take their time. Most people assume they're not allowed to leave. They sit there answering questions, handing over documents. Meanwhile, if you're not being detained, you have every right to drive away. This works because officers never clarify whether you're free to go. They act like you're required to stay. The authority they project makes you think you have no choice. People who never ask this end up in 30-minute roadside interrogations that were legally voluntary. On body camera footage, you see the moment a driver asks, "Am I free to leave?" and the officer hesitates. Now they have to commit. If yes, encounter over. If no, they need legal justification. Officer training teaches agents to avoid answering directly. They'll say, "I just have a few more questions," or "This will only take a minute." That's deflection. Your countermove is to repeat the question. Here's exactly what you say. "Officer, am I free to leave?" Deliver it calmly, firmly, no attitude, just a direct question. If they say yes, you say, "Thank you, officer," and drive away. If they say no, you've established you're being detained, which triggers higher constitutional protections. Strategic advantage, you've forced them to define the encounter, voluntary or detention. That legal distinction matters. Lock this in. Am I free to leave? Say it 3 times right now. Am I free to leave? Am I free to leave? Am I free to leave? That countermove forces ICE to show their hand, but agents have a backup tactic. They shift to asking questions designed to get you talking. Questions about where you were born, where you're going, your immigration status. If you answer even one, you've given them what they're fishing for. Countermove number 2 ends their interrogation. I'm invoking my right to remain silent. Here's what this looks like. The agent leans in. Officer asks, "Where are you coming from today?" Seems harmless, right? Wrong. That question is bait. You say your workplace. Now they know where you work. They ask, "Are you a citizen?" You hesitate. That tells them everything. Or you answer honestly, and now they have grounds. This works because questions sound casual, conversational, like small talk. But every answer is intelligence. Every word is being documented. You are not required to answer immigration questions during a traffic stop. Fifth Amendment protects your right to silence. All individuals in the United States, regardless of status, have this protection. Video evidence shows drivers talking themselves into detention. One documented Chicago case involved a driver who answered 7 questions about workplace, route, and family. None were required. All that information was used to extend the stop. Officer training specifically teaches open-ended questions that keep you talking. The more you talk, the more they learn. The more they learn, the more leverage they have. Your countermove is to invoke silence explicitly. Here's the exact line. I'm invoking my right to remain silent. Not, I don't want to talk. Not, maybe I shouldn't answer. You must use, I'm invoking my right to remain silent. Under Berghuis versus Tompkins, silence must be unambiguous. If you just stay quiet without invoking, that's not enough. They can keep questioning, but once you invoke, legally they're supposed to stop. Deliver it calmly, clearly, with no explanation. Tactical advantage, you've cut off their intelligence gathering. They can't use your words because you're not giving them any. Say this 3 times. I'm invoking my right to remain silent. I'm invoking my right to remain silent. I'm invoking my right to remain silent. You've shut down their fishing expedition with silence, but agents are trained on what to do when drivers invoke rights. They pressure you. They try to break your resolve by making you feel like invoking rights makes you look guilty. Here's their next move. They suggest things will go easier if you just talk. That's when you deploy countermove number 3. I want to speak with an attorney. After you invoke silence, officers say, "Look, I'm just trying to help you out, or if you cooperate, this will be quick." This is psychological manipulation designed to make you think staying silent is wrong, that talking will benefit you. Field reality proves the opposite. Once you've invoked silence, anything you say after can still be used if they claim you reinitiated conversation. That's the trap. You think you're being helpful, but you're waiving the protection you just invoked. Officer training includes specific techniques to overcome silence invocations. Build rapport, seem friendly, make small talk that gets you talking. The moment you respond to a casual comment, they can argue you abandoned your invocation. Your counter move adds a second layer. I want to speak with an attorney. Under Davis versus United States, requesting an attorney should terminate all questioning immediately, not reduce it. End it. When the officer tries to pressure you after you've invoked silence, you say, "I want to speak with an attorney." Calm, clear, final. Not, "I think I should talk to a lawyer." Not, "Maybe I need legal advice." You want to speak with an attorney. That exact phrasing matters. Tactical advantage. You've invoked 2 separate rights. Silence and counsel. They can't question you without violating clearly established law. Even if they keep talking, repeat the line. Let's compare wrong move to counter move. Wrong move. After invoking silence, officer says this could go faster if you answer questions. You say, "Okay, what do you want to know?" You waived your invocation. Counter move. Same scenario. Officer says this could go faster. You say, "I want to speak with an attorney." Nothing else. Encounter over. Lock this in. Say it 3 times. I want to speak with an attorney. I want to speak with an attorney. I want to speak with an attorney. You've invoked silence and counsel, but there's one more tactic ICE deploys that catches even people who know their rights. The search request. If you consent, everything we covered becomes irrelevant because you've given them access to your vehicle and anything in plain view. Countermove 4 protects your Fourth Amendment rights. I do not consent to searches. Here's what happens. The agent asks, "Can I take a look in your trunk?" Or, "Mind if I check inside?" They frame it casually, like it's no big deal. Most people say, "Sure, go ahead." That's the consent trap. The moment you say yes, they don't need a warrant or probable cause. They have your permission. Once inside, they're looking for anything that gives them leverage. Immigration documents, foreign identification, anything suggesting status questions. Even if they find nothing criminal, the search extends the stop, gives them time to run checks, increases chances of finding some basis to detain you. This works because of how the request is framed. They don't demand. They ask. They make it sound optional, friendly. But here's reality. You are never required to consent to a search without a warrant. Under the Fourth Amendment, they need your consent, probable cause, or a judicial warrant signed by a judge, not an ICE administrative warrant, a real warrant from a court. Officer training teaches that consent is the easiest path to search. If you say yes, they don't have to justify anything. Your counter move. Deny consent explicitly and control your window. First, your window. Crack it 2 to 3 inches maximum, just enough to communicate and pass documents through. Do not roll it all the way down. A fully open window gives them better plain view access and makes it easier to reach inside. Keep it cracked. Second, when they ask to search, here's your response. I do not consent to searches. Not, I'd rather you didn't. Not, I don't think that's necessary. I do not consent to searches. Clear, unambiguous, polite, but firm. Tactical advantage is twofold. 1, you've eliminated consent as a legal basis for search. 2, if they search anyway without a warrant or probable cause, you've preserved your ability to challenge that search later. On video, your refusal is documented. Lock this in. Say it 3 times. I do not consent to searches. I do not consent to searches. I do not consent to searches. Keep that window cracked, not open. Now let's talk about physical tactical protocol for ICE vehicle stops, because how you set up the encounter in the first 60 seconds determines your tactical position. When you see lights behind you, even if unmarked, here's your procedure. Signal and pull over at a well-lit visible location. If night, find a gas station or area with cameras. Stop the vehicle. Engine off. Keys on dashboard visible. Turn on interior dome light if dark. Hands at 10 and 2. Completely visible. Do not reach for anything until instructed. Lock your doors. Locked doors require them to ask you to unlock, which is another request you can evaluate. Window cracked 2 to 3 inches. No more. When the agent approaches, say for everyone's safety, I'm recording this interaction as well. This is protective for both parties. If they have body cameras and you're recording, that's dual documentation. If they question why, say just for transparency and accuracy, officer, do not hand over your phone. Keep it mounted, capturing audio and video. Now, the critical distinction, request versus order. This determines what you're legally required to do. When an agent tells you to do something, ask officer, are you requesting or ordering me to do that? If request, you have tactical option to decline. Example, officer asks, can you step out? You ask, is that a request or order? If request, you say, I prefer to remain in my vehicle. If order, under Pennsylvania versus Mims, they can order you out for officer safety. But here's your counter before complying. What is the lawful basis for this order? This creates a record. Then, as you comply, say, I'm complying under your order. My hands will remain visible. This shows compliance wasn't voluntary, it was compelled. That distinction matters if the order was unlawful. For documents, if you're the driver, you must show your driver's license when requested in most states, but pass it through the cracked window. Do not open your door. Do not step out unless ordered. If you're a passenger, you generally do not have to provide identification to ICE during a traffic stop unless under arrest. You've set up your tactical position, controlled your window, and made the request versus order distinction. But there's another layer most people miss. Your recording plus their body cameras equals your tactical advantage, and understanding warrant types they might reference is critical because ICE uses language designed to sound more authoritative than it legally is. When you state for everyone's safety, I'm recording this interaction, you're doing 3 things. 1. Creating independent documentation that can contradict their report if needed. 2. Putting them on notice that their actions are being captured, which often moderates behavior. 3. Protecting yourself against claims you did or said something you didn't. Your recording is legal in nearly every state for encounters in public or during traffic stops. ICE agents may not like it, but they can't legally stop you from recording. Keep your phone visible, keep recording, and if they tell you to put it away, you say respectfully, officer, I'm exercising my right to record this public interaction. Now, here's the warrant issue that confuses most people. ICE agents may reference a warrant during a vehicle stop, but not all warrants are created equal. An administrative warrant is an ICE form, typically an I-200 or I-205, signed by an ICE supervisor. It is not signed by a judge. It does not give them authority to enter your home, and it does not give them authority to forcibly enter your locked vehicle without your consent or probable cause. A judicial warrant is signed by a neutral judge, typically from a U.S. district court. That is a court order with legal authority to compel entry in specific circumstances. If an agent claims they have a warrant, you ask to see it. You can ask them to hold it up to your cracked window so you can read it. Check for a judge's signature and the court name at the top. If it's an administrative warrant, it does not authorize forced entry into your car. You say, I see this is an administrative warrant signed by an immigration officer, not a judge. I do not consent to entry or search. Stay calm, stay tactical, stay in control. Composure is your force multiplier in these encounters. Do not match their energy. Do not show attitude. Do not argue. You deploy your counter moves with calm precision. Cooperation does not equal conversation. You can be polite and still assert every single right you have. Your composure is your tactical advantage. Here's what to avoid. Don't make fast movements. Don't reach for anything without announcing it first. If you need to get your registration from the glove box, you say, Officer, my registration is in the glove box. I'm reaching for it now. Slow, visible, narrated. Don't surrender your composure. The moment you get emotional, you lose control of the encounter. Be polite, not talkative. Firm, not hostile. Now let's address what happens when you don't deploy these counter moves and the escalation path if your tactics fail, because understanding the full tactical landscape means knowing both how to prevent detention and what happens if prevention doesn't work. Under the settlement in Castanon-Nava versus Department of Homeland Security, ICE is prohibited from conducting pretextual traffic stops in certain jurisdictions, including Illinois, Indiana, Wisconsin, Missouri, Kansas, and Kentucky. A pretextual stop is when they claim they pulled you over for a traffic violation, but the real reason was immigration enforcement. The settlement requires ICE officers to document the specific, articulable facts that justified the stop and prohibits them from telling you the stop is for a traffic violation when it's really about immigration status. Nationwide, ICE must have reasonable suspicion based on specific facts that someone in the vehicle lacks lawful status before stopping the vehicle. They can't rely solely on race or ethnicity, although recent Supreme Court guidance in Noem versus Perdomo allows apparent ethnicity to be one factor among others. If you believe you were stopped based on racial profiling, document everything: the agent's name and badge number if visible, the time, location, what they said, and how they justified the stop. That documentation supports a legal challenge later. Now, the escalation path if your tactics don't prevent detention. If they detain you despite your invocations, here's what happens next. They can fingerprint you if they have reasonable suspicion of immigration violations. You do not have to answer questions even during fingerprinting. If they arrest you, they must provide you access to a phone to contact family or an attorney. You have the right to contact your consulate if you're a foreign national. You do not have to sign anything without speaking to an attorney first. ICE detention does not automatically mean deportation, but it does mean you need legal representation immediately. In custody, you still have your rights. You can still refuse to answer questions. You can still request an attorney. Anything you say in detention can be used in immigration proceedings. ICE vehicle stops are designed to gather intelligence and create opportunities for detention. Every question they ask, every request they make, every moment you stay engaged is an opportunity for them to build their case. Your 4 counter moves cut off those opportunities at every stage. Here's the field rule that covers everything we've discussed. Control the interaction, control the information, control the outcome. ICE vehicle stops are intelligence-gathering operations. Your job is to deny them intelligence while asserting your constitutional protections at every decision point. The 4 counter moves are your tactical playbook. Let me give them to you one more time. Counter move 1. Am I free to leave? This forces them to define the encounter, consensual or detention. If consensual, you leave. If detention, they need justification. Counter move 2. I'm invoking my right to remain silent. This ends their interrogation. No more questions about where you're from, where you're going, or your status. Silence is your shield. Counter move 3. I want to speak with an attorney. This terminates questioning completely. It's the nuclear option that shuts down all further attempts to get you talking. Counter move 4. I do not consent to searches. This protects your Fourth Amendment rights. No consent means they need a warrant or probable cause. Without your yes, they have to justify everything. Right now, practice saying these out loud 3 times each. Am I free to leave? Am I free to leave? Am I free to leave? I'm invoking my right to remain silent. I'm invoking my right to remain silent. I'm invoking my right to remain silent. I want to speak with an attorney. I want to speak with an attorney. I want to speak with an attorney. I do not consent to searches. I do not consent to searches. I do not consent to searches. Memorize these. Drill them until they're automatic. Because in the moment, when an unmarked car is behind you and masked agents approach your window, you won't have time to think. You need these responses ready. This is tactical education only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. If this tactical intelligence helped you understand how to control ICE vehicle encounters, hit the like button. Subscribe to this channel for more traffic stop tactics that put you in control. Hit the bell so you never miss an update. And share this video with anyone who needs to know how to protect themselves during ICE stops. You just learned 4 countermoves that shut down ICE fishing expeditions during vehicle stops. But the most prepared drivers have responses ready for every scenario immigration agents throw at them. The next video adds more tools to your tactical arsenal. It's on screen right now. Click it while this training is fresh. You never know which situation you'll face next. Tell me in the comments, where in the world are you and what time is it there? Know the tactics. Own the encounter.